We expect, this is surmising based on what we know about the reporting on the grand jury proceedings. We expect that Manhattan DA Alvin Bragg is going to be charging Trump with multiple felonies based on a violation of the state's Business Records Act, combined with an allegation that he violated federal campaign disclosure laws. And the latter allows him to level up the state charge, which is normally a misdemeanor, to a felony. So what about that bootstrapping of federal election law?
Yeah, he's trying to enforce a federal election law when he is a state official.
Well, here
I mean, clearly this. I don't think I'm not a lawyer, but how is this going to work on appeal? I mean, he's got to know that.
Assuming it gets to appeal, assuming that Trump selects a jury trial, it just takes one, even in Manhattan. But here's what Trump's lead criminal defense attorney, Joe Tacopina, had to say about that FEC angle, that argument, on CNN over the weekend.
No, it can't be. This was a federal presidential election. The allegation here, in some Twilight Zone sort of scenario, is that he settled the civil case 6 years earlier, something that happens, by the way, all the time. A civil case was settled with confidentiality agreements between a lawyer that was representing him and a lawyer representing the Stormy Daniels. Trump didn't even sign that settlement agreement, so they signed it. The lawyer financed it, subsequently gave him a host of invoices for legal services over the course of a year. They were recorded, but understand, here's the key distinction, Dana. They were recorded in their entries. They were never filed anywhere. They were never filed with the IRS. They never took a tax deduction, and they were never filed with the FEC because they weren't required to. This was a personal expenditure, not a campaign expenditure. Had it been a campaign expenditure, he would have used campaign funds, and then, of course, we'd be talking about here today the outrage that Donald Trump used campaign funds for personal expenditure. Right. They'd be baying for his scalp. It's a completely upside-down world. So he's damned if he did and damned if he didn't. So those are misdemeanors, by the way, the record entries, which don't exist. They're not false entries, but assuming they were, they're misdemeanors way beyond the statute of limitations. So they had to cobble them together to try and get a felony.
The opinion a lot of people, myself included, have been relying on in terms of understanding federal election law is that of Bradley Smith. And he, in an op-ed in the Wall Street Journal, really did a nice job of distilling the law here. And we're pleased to have Bradley Smith join us now. He's the chairman of the Institute for Free Speech and the Blackmore Nault Professor of Law at Capitol University. And the fact that you need an Institute for Free Speech on a university says a lot about where free speech is in this country at present. He also served, did Bradley Smith, on the Federal Election Commission from 2000 to 2005. Brad Smith, thanks so much for joining us. Appreciate it.
Thanks, Dan. It's a pleasure.
So this op-ed that you wrote in the Journal, there's a really straightforward breakdown of federal election law regarding an expenditure like this. Explain it to us. Explain why this is a personal expenditure and so it does not implicate federal election law.
Okay. Well, first, let me just give the common sense thing that I think most people would recognize if they think about it. Do you think that paying hush money to an alleged former mistress is a campaign expenditure for office? I think most people think no. I think when they write that little check or donate online, that's not what they're thinking their funds will go for. They're thinking their funds are going to go for advertising, a campaign manager, that sort of thing. Now let's get into the technicalities of the law. What the prosecutors tend to rely on in this sort of situation, or at least this prosecutor seems to be relying on, and again, we haven't seen the actual indictment, but it's the theory that the Federal Election Campaign Act, which governs the federal law, provides that an expenditure is anything done for the purpose of influencing an election. Okay, that's the important phrase, for the purpose of influencing an election. And apparently Bragg says, well, the reason they paid off Stormy Daniels was to keep her quiet so it wouldn't reflect badly on him in the election. Therefore, it's for the purpose of influencing a federal election. Case closed, right? We've got another crime, and the records offense was intended to cover that up. The problem with that is that the federal statute, when it says for the purpose of influencing an election, is not using a subjective standard. In other words, what did the spender think? They're using an objective standard. So if, for example, I went out and I bought a whole bunch of TV ads saying, Donald Trump is a ding-dong daddy from Dumas Bay, right? Because I thought that would really help him win the election or maybe lose the election. I don't know. It wouldn't become a campaign expenditure simply because that was my purpose. The purpose is an objective standard. So, for example, the Supreme Courts have clearly held that to count something like that as an expenditure, you actually have to say elect, defeat, vote for, that sort of thing to get at the person. Or to be a little more realistic, let's suppose I give money to the National Rifle Association, because I think they do a really good job mobilizing voters. I think they do it better than the Republican Party. And so if I want Trump to win, I want to give money to the NRA. Doesn't matter. It's not a campaign expenditure, right? Because the NRA generally talks about gun rights and urges their people to vote and so on. They're not campaigning for a particular candidate for office, at least not in that general context. Might be different if I gave to the NRA PAC, but I'm just giving to the NRA, right? So we see that even though the spender or the contributor has the purpose of influencing the election, it's not a contribution under federal law. To use more examples, you suggested, or Joe, Trump's attorney suggested that businessmen settle lawsuits all the time, and I use that example a lot. Suppose that a businessman, and they do, you always have lawsuits going on if you have a lot of business interests. Some are good, some are not. So let's suppose a businessman says, "Okay, I'm going to run for office." He goes to his corporate counsel. He says, I think all these lawsuits pending against us are bogus. I think they're a bunch of nonsense, but I don't want them hanging over my head. I don't want the press mucking around in there when I run for office. So let's just settle those. Whatever it costs, settle those. Now, his purpose is clearly to influence his election, but he can't pay for those settlements of his business debts with campaign funds, right? Can't do that. So that's what we're talking about. Not everything that might be, subjectively for the purpose of influencing a campaign counts under federal law as for the purpose of influencing a campaign. What counts are you pay for advertising. A person doesn't hire a campaign manager if they're not running for office. A person doesn't open campaign offices if they're not running for offices. But people do, buy a nice new suit of clothes that they wouldn't otherwise buy to run for office, but they still have to buy clothes whether they're running for office or not. People do, in rare occasions, have to pay hush money to people whether they're running for office or not. So that's the distinction.
Yeah, and you have this elegant and statement in your op-ed that I think Tacopina should cut and paste. You write, they don't pay for personal expenses not created by the act of campaigning. That's the predicate act, even if the candidate intends for them to benefit the campaign. But don't pay for personal expenses, campaign funds, not created by the act of campaigning, and that's clearly not the case here. I mean, the contrary example would be, people in Chicagoland know this, Jesse Jackson Jr. Jesse Jackson Jr. used campaign funds to buy Bruce Lee memorabilia and Michael Jackson memorabilia, and he was prosecuted for that because that's not what campaign funds are allowed to be used for. That's clearly a personal expense. And so Tacopina is right to say if he had paid the hash payment out of campaign funds, then he would be subject to FEC prosecution.
That's right. We clearly have that sense in this prosecution that they want to go out and get him, and they would have gotten him either way. Some of the examples I use, for example, again, let's suppose you decide to run for office, and you say, I'm going to be in televised debates. I need to look really good. And you go out and buy a $3,000 suit. And you would never buy a $3,000 suit if you weren't running for office, right? Therefore, is that a campaign expense? You bought the suit because your purpose was to influence the campaign. The answer is no. That's not a campaign expense. You have to buy clothing. People buy clothing all the time, right? And
right.
So that's not something that you do just because you're running for office.
So, if, again, you said it, I said it, and everybody said it, we don't know what's in the indictment. It hasn't been unsealed. We'll find out tomorrow. But if it's what everybody expects it to be based on the witnesses that were called and the arguments that have been made and the underlying facts that have been reviewed any number of times by any number of prosecutors' offices over the last half a dozen years, if it's what we suspect. So, I mean, if put yourself in Alvin Bragg's position, is it just turn on his expansive interpretation of the phrase, or does he have anything else to work with to bootstrap an FEC claim into upcharging the Business Records Act in New York?
Well, I think basically it's his expansive interpretation of the phrase. There's been very little actual judicial rulings on this, but I want to point out two things. One pro-Bragg and one anti-Bragg, right? The anti-Bragg thing is that the Federal Election Commission regulations also make clear that something is not a campaign expenditure simply because one of the purposes, or maybe even the primary purpose, is to influence the campaign. It again has to meet that standard that we talked about earlier. That the only reason you're doing this, you wouldn't do this at all. Nobody would if you weren't running for office. Like again, running TV ads, say vote for Brad Smith. I don't do that unless I'm running for office. Okay.
Sorry to interrupt, but and the nobody would do this. That's sort of like the reasonable man standard.
Yeah. And in this case, of course, again, the reasonable man standard is, like I say, you don't run an ad if you're not running for office.
Right.
No reasonable person runs ads if they're not planning to run for office. So the FEC regulations support further that reading of the law, and I think is correct. Now, Bragg has one small point in his favor, which is a decade or so ago, some folks may remember John Edwards, the former Democratic vice presidential candidate, was in a similar situation where some of his donors were paying a woman named Riley Hunter, I think was her last name.
Mm-hmm.
She actually had a child by him, and they were paying her living expenses and so on. And a federal prosecutor tried to convict Edwards and the donors on campaign finance violations. The judge let that case go to trial, suggesting that the judge was willing to view that as a viable theory. Now, it's worth noting, though, that Edwards was not convicted. The jury hung on some counts and found in his favor on others. So there's that one kind of slim precedent that one federal district court judge let a case go to trial on that theory. It's not the same as if the judge actually ruled concretely on the theory. It was never subject to appellate review and so on. But Bragg does have that, and we have to give him that.
I wanted to get your take on another case that we've talked about a bit on this show, but it implicates the First Amendment too. This is the Douglas Mackey case, also known as Ricky Vaughn. That was his Twitter persona. He was the individual, to refresh everybody's recollection, back in 2016 presidential election. He posted sort of fake ads, fake GOTV, get out the vote ads to go vote for Hillary Clinton, and said, you vote by email or vote by text this number, and you have your vote counted for Hillary Clinton. And he was charged by federal prosecutors with election interference, Eastern District of New York. Here we go. We're in New York again. And this has been seen by many, myself included, as really a dangerous precedent to be set with respect to people's First Amendment rights, political speech in particular, if he were convicted. And after a number of days of deliberation, including with an Allen instruction, he was found guilty of election interference. What's your reaction to the guilty verdict in that case and the implications of that verdict?
Yeah, he's prosecuted under an old law, civil rights statute that prohibits attempting to influence, to interfere with a person's right to vote. I think if we look at the statute, we're clearly talking an era in which there was, direct attempts to influence or to interfere with a person's voting. That is, blocking the polls, lynching people, beating people up, that sort of thing. I don't think it was intended to get at people speaking about an election, and particularly in something, what's not clear is to what extent Vaughn thought, or Mackey, whatever we want to call him, thought that this was at all a serious kind of thing. I mean, it was kind of funny at the time. And my understanding is that the prosecutor actually could not point to a single person who actually did not vote because they read these ads saying, "Oh yeah, just text your vote," and fell for that. And I do think it gets into that kind of very dangerous area where, look, I mean, we know what Democrats have been doing. If some Republican says, well, I think there's fraud, they're arguing that that's, factually false and therefore can be punished and so on. And, one can see that. Why not say that that's an effort to discourage people from exercising their right to vote by claiming that there is fraud or there's going to be fraud, or by making some kind of other charge against a candidate. So I do think it gets us into a very dangerous area.
Well, I mean, it would be like if I tweeted out tomorrow's Chicago's mayoral election, if I tweeted out the sarcastic cliche in Chicago, today's election day, vote early, vote often. Am I guilty of election interference because I'm promoting election fraud on election day in that race?
Yeah, that's a good point. And think about it. We're just past April Fool's Day. How many people tweet out junk like that on April Fool's Day, right? Say, yeah, today's the day to go vote or something. And one of the things that just strikes me about this prosecution, so many of these things we see going on right now against Trump, against some other protesters, some of the people who were just kind of vaguely attending January 6th, that sort of thing, is this effort to extend the reach of these laws to punish people that you don't like politically, where normally prosecutorial discretion would say, let it go. This isn't a big deal.
He is Bradley Smith, chairman of the Institute for Free Speech and the Blackmore Nault Professor of Law at Capital University. He also served on the Federal Election Commission from 2000 to 2005, and his views on federal election law have been very influential in this case. I know Trump's lawyers are relying on them as well. Bradley Smith, thanks so much for joining us and explaining this. We appreciate it.
Thanks, Dan. I appreciate it.
And he joined us on the Turnkey.Pro answer line.
It's like a hot, steaming cup of information to start your day. It's Chicago's Morning Answer on AM 560.